The new red gate was still humming when Vanessa Kline called 911. It stood across the only entrance to Hawthorn Ridge, bolted into fresh concrete between two stone columns that had been part of my family's farm since 1956. .53's my old chain lay on the shoulder in two pieces. A white card reader blinked beside the road, and a laminated notice ordered unauthorized persons to leave. I arrived at 7:42 that Tuesday morning with a blue binder under my arm. .85's. Vanessa stepped in front of the gate before I reached the cut chain. "He is attempting to breach our security entrance," she told the dispatcher. Her voice was careful and official. "He has already claimed ownership of association property. We need an arrest before residents begin leaving for work." 053's. I did not touch the gate. I photographed the concrete while it was still pale. The serial plate on the card reader, the cut ends of my chain, and the orange cable marks along the shoulder. Then I wrote the time beside each photograph. The patrol officer arrived 9 minutes later. Vanessa handed her a board resolution. I handed her a recorded deed, a parcel map, and nothing else. .85's officer Alina Ruiz read both beside the hood of her car. She looked at the stone columns, then at the map, then back at Vanessa. "Ma'am," she said, "he owns the neighborhood." 1.5 Vanessa stopped speaking. Officer Ruiz raised one hand before the sentence could become more than it meant. "Not the houses. He owns this road, the reserve, the entrance, and the land under the signs you are calling association property. I am not arresting him for standing on his own parcel." .53's that should have ended the morning. It did not. 47 families still held a recorded right to use the road. The gate was still bolted into my soil. And inside Vanessa's black folio was a second document that would put a $9,600 claim against my land before the week was over. .85's I had owned the Hale Reserve for 14 days. My uncle Raymond had called it that long before any lawyer placed the words on a plat. To him, it was simply the lower meadow, the orchard, the creek path, and the narrow loop road he built with a borrowed grader. .53's Hawthorn Ridge came later, after he sold home sites along the wooded slopes but retained 16.8 acres through the middle. I was 61 when Raymond died. For most of my career, I estimated municipal utility projects. 53's I read scopes, quantities, bids, change orders, and payment records. A number could be wrong for an innocent reason. A date rarely moved by itself. If a crew claimed it had installed a valve on Wednesday, but the concrete ticket showed Tuesday, I did not accuse anyone. .53's I put both papers beside each other and asked what happened. Raymond liked that habit. During my teenage summers, he would hand me a fence staple box filled with receipts and ask me to sort them by year. 53's land remembers what people forget, he once said. The reserve was not grand land. Alder Creek became ankle-deep by August. Half the apple trees leaned east after an ice storm. 53's the stone pump house had not pumped water in 20 years, but it was where Raymond taught me to drive a tractor. Where my late wife, Ellen, planted a row of daffodils, and where I had promised him that access would remain fair, without turning his meadow into somebody else's amenity. 0.53's that distinction mattered. Raymond never wanted to trap the homeowners. Their deeds carried a non-exclusive easement over the loop road, so residents, guests, deliveries, and emergency vehicles could enter and leave. 0.85's the association collected money to maintain the pavement. In return, Raymond allowed a modest entrance sign and seasonal landscaping near the stone columns. Use was not ownership, maintenance was not possession, and permission did not become title merely because it lasted a long time. .85's 2 days after the funeral, Raymond's attorney gave me a cardboard records box and the key to the pump house. The box held the recorded 1998 plat, the deed into the Hale family trust, tax receipts, road invoices, and a thin binder of insurance certificates. .85's tucked into the front pocket were annual checks from the association, each for $1. I almost laughed when I saw them. Raymond had never cashed checks quickly. Several carried coffee rings, and one had an Appleseed impression pressed into the paper. .53's on the memo line. Every check said the same thing: annual road license. I noted the phrase and returned the checks to the binder. At that point, I saw them as evidence of Raymond's cautious nature. Nothing more. 53's the first sign of trouble came at the county recorder's office. That office did not decide who won a land dispute. It maintained filed deeds, plats, and easements so the public could see what had been recorded. .85's. I asked for certified copies of every instrument indexed to the reserve and every amendment filed by Hawthorn Ridge. The clerk placed 3 stacks on the counter. The declaration governing the 47 residential lots was thick. Below .53's its exhibit listed every lot by number. Hale Reserve was not among them. A later amendment changed fence colors and roof materials. Another created a process for collecting unpaid assessments. .85's none annexed the reserve. The road easement was only 4 pages. It allowed passage and ordinary maintenance within a defined strip. It prohibited the landowner from blocking reasonable access. It also required written owner approval for gates, control devices, structures, or alterations beyond routine surface maintenance. Point 85's the red gate had not been installed yet, but the phrase control devices caught my attention. I asked the clerk whether any approval signed by Raymond had been recorded with the easement. Point 85's she searched twice. Nothing under his name or the trust. I wrote the date, her name, and the search terms in my notebook. Then I ordered certified copies and drove to the reserve. 85's. The entrance still looked ordinary that afternoon. The weathered chain hung loose between the left column and an oak post. Raymond used it only to close the orchard lane, never the paved road. Loft 3's. The association sign sat 6 feet inside the easement. Fresh orange paint marked a rectangle beside the right column. 2 small utility flags stood where no utility line appeared on the county map. Point 53's. I photographed them from the road shoulder. I measured their distance from the column. Then I walked to the pump house and opened the door with Raymond's key inside beneath a film of stone dust. I found a white contractor envelope addressed to Vanessa Kline. 0.85's. It had been pushed through the gap under the door. The return label belonged to Gateshear Access Systems. I did not open it because it was not mine. I photographed the envelope where it lay and called the number printed on the label. 85's. A project coordinator named Lewis answered. I identified myself as the landowner and asked whether his company had scheduled work on the reserve. He became cautious. We have an association authorization for Thursday. Point 53's. Does your file include written approval from the record owner? There was a pause, then keyboard sounds. The project note says owner approval pending 1.2's. I wrote the exact phrase. Would you email that to me? I can release the customer file, but I can tell our operations manager. There is an ownership question, please do. I am not authorizing excavation. I sent a short email to Vanessa that evening. Whole point 85's. I attached the deed, the plat page, and the easement. I did not accuse her of anything. I asked her to pause all work until the association could show written owner approval. 0.85's. Her reply arrived 11 minutes later. Hawthorn Ridge has controlled and maintained its entrance for more than 15 years. Your interference with established security infrastructure will be treated as a hostile act against 47 families. 0.53's. She did not attach an approval. I printed the message, placed it behind the easement, and wrote 6:18 p.m. in the margin. Gateshear did not arrive Thursday. Its operations manager called me at 8:05 that morning and said the job had been placed on hold until its customer resolved the ownership question. 0.85's. That was a small relief, not a victory. A contractor could refuse uncertain work. It could not interpret the easement for us, and it could not prevent Vanessa from hiring someone else. 0.85's. On Friday. The orange rectangle beside the stone column was repainted in blue. The original utility flags disappeared. A new set appeared 2 feet farther from the road. Someone had also slipped a laminated notice under the pump house door. 0.85's. The notice announced a special board meeting for Monday evening. The only agenda item was emergency entrance security and owner obstruction. I attended without speaking until public comment. Vanessa sat at the center of a folding table in the elementary school library. 0.53's. She wore a red blazer and kept a black folio open beside the association seal. About 30 residents filled the chairs. She described me as the successor to a developer interest that had expired when the subdivision was completed. 0.53's. She said the association had paid for the road, insured it, landscaped it, and controlled access for years. Some of that was true. The association had paid for resurfacing. Its policy covered incidents on the road. 0.53's. Residents relied on it every day. Then Vanessa said, no individual can suddenly claim the entrance to an established community. I placed a copy of the plat on the table. 0.85's. I am not claiming it, suddenly. The deed has been recorded since 1998. You are relying on old technical language against 47 households. I am relying on the language that created their access. 0.53's. The vice president asked whether I intended to close the road. No, the easement prevents that, and I have no wish to do it. Then why oppose a gate? Because a gate can fail. It can delay an ambulance. It can also be used to exclude the landowner. The easement requires written owner approval, and no one asked. 0.85's. Vanessa closed the folio. The board has legal advice. May I see the opinion? It is privileged. I nodded. Then, please record that I requested the authority for construction and none was produced. 0.85's. The board went into a closed session. 23 minutes later, it returned and adopted an emergency resolution. The resolution authorized all necessary measures to secure the entrance and directed management to recover costs from any person who interfered. 0.85's. Ben Calder, the treasurer, He did not raise his hand with the others. Vanessa looked at him. Ben? He adjusted his reading glasses. I abstain. We do not have the owner approval in the packet. 0.85s. Her expression remained controlled. Your abstention is noted. I noted it too. The next morning, before sunrise, a different contractor installed the red gate. By the time I arrived at 7:42, the concrete footings were already hard enough to hold it upright. 0.53s. The crew had cut Raymond S. chain, drilled through the old oak post, and laid conduit to the white reader. Their truck had no gate year markings. Vanessa S. 911 call brought Officer Ruiz into a situation the board had apparently expected to control. 0.53s. After Officer Ruiz read the documents, she asked Vanessa one direct question. What crime are you reporting? Trespass and attempted damage to association security equipment. Did he damage the gate? He said he would not authorize it. 0.53s. That is not damage. Vanessa pointed toward me. He has tools in his truck. Officer Ruiz glanced through the windshield. A socket set sat behind the passenger seat. So did a rain jacket and a bag of grass seed. 0.53s. Has he removed anything? Not yet. Officer Ruiz turned to me. Do the homeowners have an easement over this road? Yes. Are you planning to block their access this morning? 0.53s. No. She explained that she would document the disagreement and keep the peace, but she would not decide the full property issue. Her comment about my ownership described the public records in front of her. Line 85s. It did not cancel the homeowner's easement, remove the gate, or make the association's conduct criminal. That restraint mattered. A patrol officer was not a title judge. I did not ask her to become one. 0.53s. Before leaving, she gave both of us the report number. She also asked the contractor supervisor to stop drilling until the party spoke with counsel. He agreed because his crew had completed the basic installation. 0.53s. The red arm remained raised. Residents drove beneath it. The card reader kept blinking. Vanessa stepped close enough that the officer could still hear her. This is not over, Mr. Hale. I know the association will assess every dollar of delay to you. 5-3. I wrote her words down while she watched. At 9:30, I called Miriam Cole, a property attorney whose office was 1 county west. Raymond had consulted her years earlier about a drainage culvert. 0.53s. She remembered the reserve. Miriam listened without interrupting. Then she asked me to send the deed. Plat, easement, declaration, board notice, resolution, emails, photographs, and police report number. Do not cut the lock, she said. 0.53s. There is no lock on the raised arm. Do not touch the arm either. Their strongest argument will be that you threatened access. Give them no photograph that supports it. 0.85s. By noon, she had the documents. At 4, we met in her office. She arranged the papers in 3 columns. The first column showed title. The Hale Family Trust had retained the reserve, and the deed had passed it to me. 0.85s. The second showed the declaration. The HOA governed the residential lots, not the reserve. The third showed the easement. It granted the lot owners access and permitted ordinary maintenance. It did not grant the association exclusive possession or authority to install control devices without written approval. 0.85s. On paper. Your position is strong, Miriam said. I waited. Lawyers rarely use that sentence without a second half. But paper is not the whole dispute. They have maintained the road for 15 years. They may argue, your uncle allowed the association to behave as if it controlled the entrance. They could ask a court to preserve the status quo while that history is examined. 1.2s. The status quo did not include a gate. Correct, but if they frame the gate as emergency security tied to 47 homes, a judge may be cautious about ordering immediate removal. 0.85s. She tapped Vanessa S. email. This helps because it shows notice. The contractor S. owner approval pending note may help more, if we can obtain it right now, however. It is your account of a phone call. 5-3s. I opened Raymond's thin binder and showed her the $1 checks. Miriam read the memo lines. Where did these come from? His records box. All years? 11 checks. Some years may be missing. She did not call them decisive. She asked whether the bank could provide images showing which checks had cleared, when whether association ledgers identified the payments. 0.85s. A license is permission, she said. If they recognized permission each year, their long use may not be as exclusive or hostile as Vanessa suggests. But we need authentication. Old paper in a family box is a lead, not a conclusion. 0.53s. That was language I understood. We made a list. I would order a boundary and easement survey. Request bank records available to the trust, preserve the original checks in sleeves, and create a daily property log. 0.85s. Miriam would send a notice demanding that the gate remain open, no further work occur, and all relevant association and contractor records be preserved. Neither of us threatened to strand residents. 0.53s. We documented first. Aaron Pike arrived at the reserve the following morning with a survey tablet, a tripod, and 3 canvas bags of equipment. He had reviewed the recorded plat before coming. .85's his first task was not to decide ownership, it was to locate the described lines and easement on the ground. I walked with him, but did not tell him where I thought the corners should be. Tank 39's, Raymond had warned me against guiding a surveyor toward the answer I wanted. Aaron found the first iron pin behind the left stone column, 4 inches below leaf litter. The second stood near the creek under a bent sycamore root. .53's by midday, his measurements placed both gate footings inside the reserve. The card reader conduit crossed beyond the maintenance strip by 19 inches. That does not erase their access. Right, he said. 5-3's. I understand. And the old entrance sign is within the strip. The pump house is outside it. The orchard lanes is outside it. Most of the meadow is outside it. 5-3's. He marked each point on a field sketch and photographed the monuments before replacing the soil. The gate crew had not moved them. That was useful because it kept the dispute narrow. .53's. We did not need a missing survey pin or a secret boundary. The board had built on land whose location was already recorded. While Aaron worked, a woman from the third house stopped near the raised arm. .53's. She introduced herself as Ruth and asked whether I was closing the road. No, Vanessa said. Emergency vehicles might lose access. The gate is hers, not mine. My attorney asked that it stay open while the documents are reviewed. 0.85's. She looked at the orange paint near the pump house. What are those marks for? I do not know yet. Ruth nodded, but did not seem reassured. I could not blame her. If someone told me a stranger had inherited the road to my home, I would want more than a calm sentence. 5-3's. That afternoon, the association management company emailed all residents. The subject line read community access threat. The message said a private claimant was challenging long-established neighborhood rights and warned that legal expenses might require a special assessment. 0.85's. My name appeared in the second paragraph. I saved the email as a PDF and printed a copy. I did not answer the neighborhood list. Public arguments create many words and very little evidence. 0.53's. The next delivery was more serious. A certified envelope from the association demanded $9,600 for gate delay, legal review, emergency security, and contractor remobilization. It said the amount would be assessed against the Hale Reserve and referred for collection if unpaid within 10 days. 0.53's. Miriam read it twice. Their declaration permits assessments against member lots, she said. Your parcel is not listed as a member lot. They may still claim reimbursement under the easement, but that is different from recording an HOA lien. 0.85's. Can they file one anyway? People can submit documents that are later challenged. The recorder accepts filings that meet formal requirements. The office does not conduct a trial at the counter. 0.85's. That practical answer troubled me more than a dramatic one. A weak lien could still cloud title, affect insurance, or force legal work to remove it. Miriam sent a response disputing the assessment and demanding the exact covenant provision that applied to the reserve. While 85, she also requested the meeting notice, attendance record, draft and final minutes, gate contract, legal invoices, insurance records, and communications about access. The board produced only the final resolution and a 2-page invoice. .85's. Ben S. abstention did not appear in the minutes. Instead, the final minutes said the resolution had passed unanimously. I compared them with the notes in my binder. My entry recorded his words exactly. I abstain. We do not have the owner approval in the packet. 0.85's. My notebook was not proof of what the official minutes should say. It was a contemporaneous record that told us what to investigate. Miriam wrote to Ben, through the association's attorney, asking whether the minutes accurately reflected his vote. .85's. He did not answer that day. The gate stayed raised for 3 days. On the 4th morning, the red arm was down. A delivery van waited outside while a resident held a card to the reader. .53's. The arm lifted slowly, then dropped before the van passed. The driver braked hard. No one was injured, but the front bumper stopped inches from the steel. I recorded the incident from the public shoulder. My camera had no useful audio, but it clearly showed the arm cycle and the van's brake lights. I sent the clip to Miriam and the property manager. The manager answered that the system was operating within programmed safety parameters. .53's. I asked for the parameters and the inspection record. No response came the next morning. My card did not work. I had never requested one, but a white envelope had appeared in my mailbox with a temporary access card after the police call. .53's. When I held it to the reader, the panel flashed red. A resident behind me lowered his window. Vanessa said, "You are not supposed to enter without an escort." I moved my truck so he could pass. 5-3's. Then I walked around the stone column, through the meadow, staying outside the road lane. My deed gave me possession of the reserve. The association had no order excluding me. 3 orange stakes stood beyond the pump house. There had been none the previous day. I followed their line across the meadow. They formed a rectangle large enough for a building and parking area. Below .53s near the last stake, a wooden lath carried a contractor's project number in black marker. I photographed the stake without pulling it. I measured from the pump house wall. I called Miriam. "Do not confront the crew if one arrives," she said. .53s ask for the site plan and authority. Record the answer. We may need emergency relief if clearing begins. At noon, a compact track loader rolled through the gate on a trailer. 0.53's Vanessa arrived behind it in a silver sport utility vehicle. She carried the black folio and spoke with the operator beside the orange rectangle. I remained 30 feet away. "Who authorized work on this parcel?" I asked. Vanessa turned. "The board authorized reserve maintenance." "What maintenance?" 5.3's, dead tree removal and safety preparation. The nearest apple tree was old but alive. White paint marked its trunk. The operator shut off the loader. He looked from Vanessa to me. "Are you the owner?" "I am the record owner. There is an access easement over the road." "Not this meadow." 8.5's. Vanessa opened her folio. "He is interfering again. We have an emergency resolution." The operator did not read it. "My work order says association common area." "This is not association common area," I said. .53's. "I will show you the deed and survey. I am asking you not to clear until your company verifies title." He called his supervisor. Vanessa called the property manager. I called no one because Miriam had instructed me to observe unless equipment moved. Go. .53's. After 6 minutes, the operator climbed back into his truck. "We are off the job until council sorts it out." Vanessa's voice sharpened, but it did not rise. "You are under contract and the contract says you own the site." 0.53's. He drove away with the loader, still chained to the trailer. Vanessa waited until the engine noise faded. "Every delay becomes part of your account." I looked at the painted apple tree. 0.39's. Was this included in the gate project? The reserve has always been planned as a community asset. It was the first time she admitted that the conflict extended beyond entrance security. Ones. I wrote the sentence down. Miriam used it in the next letter. She asked the board to identify every plan, loan application, budget, or contract that treated Hale Reserve as a community asset. .53's. The association's attorney objected that the request was broad and unrelated to the gate. Miriam answered with photographs of the orange rectangle, the marked apple tree, and the loader work order number. 0.85's. 4 days later, the board produced a site concept labeled Hawthorn Ridge Community Pavilion. It showed a small clubhouse, a swimming pool, and 30 parking spaces across the lower meadow. 0.53's. The entrance gate appeared in the lower corner, connected to the same access control system proposed for the pavilion. The concept was not a permit. It did not transfer land or authorize construction. 0.53's. But a lender term sheet attached behind it required proof that the association owned or controlled the project site before funds could be released. That explained the urgency. 1.2's. Vanessa had not installed a gate merely because residents wanted security. The board needed a record of control. If the association could treat me as an outsider, issue assessments against the reserve, manage entry, and clear the meadow without objection, it could present those facts as support for a broader claim. 0.85's. Motive did not prove title. It explained conduct. The term sheet also carried a board certification signed by Vanessa. She had certified that no third-party consent was required for site access improvements. Longton 8.5's. The date was 2 days after my email attaching the deed and easement. I placed her email and the certification side by side in the binder. Same project, same question. 2 different answers. Aaron finished his survey report the following week. 0.85's. It located the entire gate, both footings, part of the conduit, all 3 orange stakes, and the marked apple tree on the reserve. It also depicted the easement strip clearly enough that no one could confuse road access with control of the meadow. 0.85's. Miriam sent the report with a proposed solution. The gate would remain raised. The association would remove the unauthorized reader and restore the stone column area. Both sides would sign a modern road maintenance agreement confirming resident access, emergency procedures, insurance, and the reserve's excluded status. 0.3's. The association would withdraw its assessment and pavilion plan. For one afternoon, that looked possible. The association attorney asked for 48 hours to review the proposal. Ben called me that evening. "I should not be speaking without counsel," he said. 0.53's. Then do not discuss legal advice. He breathed slowly into the phone. "The minutes are wrong." I waited. I abstained. The first draft showed it. Vanessa sent back a revision saying emergency actions require a united board record. 0.85's. Do you have the first draft? I have the email attachment. Preserve it. Do not forward it to me directly. Miriam can arrange the proper exchange. There is something else. Those dollar checks you asked about through council? They are in the old ledgers. Road license renewal. Raymond invoiced us every January. 0.85s. How far back? I have seen entries through the year before he became ill. I closed my eyes for a moment. Raymond had not kept ceremonial checks. He had maintained a simple, repeated record that use depended on permission. 0.85s. Ben, why did the association keep paying? The management company said it preserved the access arrangement. Did Vanessa know? She signed 2 of the checks. That answer was important, but Ben was not yet ready to place his name behind it publicly. 0.53s. Will you tell Miriam? I need to think. Take the time you need. Preserve the records. Do not change them. The call ended without a promise. I documented it as a lead, not testimony. 0.85s. The next morning, the association rejected our proposal. Its attorney offered a different interpretation. He acknowledged that I held record title, but argued that the association's long maintenance, insurance, landscaping, and control had created rights beyond the written easement. 0.85s. He used phrases such as equitable estoppel and prescriptive use, fact-specific doctrines that can sometimes protect long-standing reliance or use. His letter said, immediate removal of the gate would create safety risks. 0.53s. It demanded that I stop interfering with association-managed portions of the reserve while the parties negotiated. The phrase portions of the reserve was new. Miriam drew a box around it. They are no longer saying they own everything. They are building an alternative position. Even if you have title, their history gives them control. 0.85s. The dollar checks answer that they may, but only if we establish what they were for, who authorized them, whether they were accepted, and whether the relevant use was permissive. Their lawyer will say a $1 bookkeeping entry cannot outweigh 15 years of conduct. 0.53s. What about the insurance certificates? We opened Raymond's thin binder again. 11 certificates named the Hale Family Trust as an additional insured and described its interest as owner of access parcel. 0.85s. Each certificate covered the loop road and entrance landscaping. The oldest predated Vanessa's presidency. The newest had expired the previous year. Miriam aligned the certificate dates with the check dates. 0.85s. These support each other. The association paid a license fee and insured the title owner against risks arising from the licensed use. Is that enough? Enough to make their theory difficult, not enough to assume they will retreat. You want 5.3s, she was right. That afternoon, a process server delivered a civil complaint and a request for temporary relief. The association asked the county court to declare broader access and management rights. While 0.85s until a full hearing, it wanted an order preventing me from disabling the gate, obstructing contractors, or interfering with safety maintenance within the claimed common use area. The pavilion concept was not mentioned. The hearing was set quickly because the association alleged a threat to the only road serving 47 homes. 0.83s. A temporary hearing would not decide final ownership. Its purpose was to keep an urgent situation from causing harm while the case proceeded. Miriam filed our response with the deed, survey, easement, Vanessa's email, photographs, and the contractor withdrawal. 0.85s. She emphasized that I had never blocked the road and had repeatedly asked that the gate remain raised. We asked for our own narrow relief. No lowering the gate, no card restriction, no construction outside routine pavement maintenance, and no lien against the reserve until the court could examine jurisdiction. 0.85s. The judge heard both sides in a small civil courtroom. Vanessa sat at counsel table in her red blazer. I sat beside Miriam with the blue binder closed. The association focused on consequences. School buses used the road. Fire equipment needed reliable entry. Residents had purchased homes believing the association managed the entrance. 0.53s. All true. Miriam focused on limits. Reliable access did not require excluding the landowner. Routine maintenance did not include a pavilion. A board resolution could not enlarge a recorded easement. 0.85s. Also true. The judge did not choose a winner that day. He ordered the gate kept open and prohibited construction in the meadow. But he also directed me not to remove, disable, or alter any existing access equipment until the evidentiary hearing. 0.53s. Vanessa walked out with the red gate still standing. The reporters were not waiting. Residents did not applaud. The order protected the road and the meadow for the moment, but it gave the association the image it wanted. Its equipment remained in place under court protection. 0.885s. Within hours, the property manager sent residents a message saying the court had preserved HOA control of community access. That was not what the order said, yet it was close enough to shape opinion. 0.53s. The following day, the association recorded a notice claiming that litigation affected rights in the reserve. It did not transfer title, but it clouded any transaction involving the property. My insurer then asked whether the dispute increased liability at the entrance. 0.53s. The cost had moved beyond a red gate. Vanessa had found the remaining gap. Our papers showed ownership and written limits. They did not yet explain, in a form ready for court, why 15 years of association conduct remained permission rather than an independent right. We spent the next 2 weeks closing that gap. The Trust S Bank could retrieve images of 8 cleared $1 checks. Each carried the Association S account information, Raymond S endorsement, and the memo annual road license. Rel 5-3s. The missing years were covered by ledger entries produced after Miriam served formal discovery requests in the civil case. The association objected to producing the old ledgers as irrelevant. The judge ordered production because the board itself had placed the history of road use at issue. 085s. The entries were brief. Road license renewal, $1. Some were approved by prior presidents. 2 bore Vanessa's initials. They appeared in the same expense category as entrance landscaping and liability coverage. 0.53s. The insurer supplied certified business records for the annual certificates. Those records identified the trust as owner of the access parcel. They also showed that the Association S agent requested the wording each year. 0.53s. These were not pieces of paper found at the last minute. I had seen them in Raymond S. box on the second day. What changed was authentication. The bank confirmed the checks. The ledger confirmed why the association issued them. 0.85s. The insurer confirmed why the trust was named. Known facts began to connect. Gacher produced its project log under a subpoena. The first authorization packet included Vanessa S. signed certification that the HOA controlled the site. 0.53s. Beneath it, the project coordinator had added the note I heard over the phone: record owner approval pending. The log also showed that Vanessa received the hold notice before the special board meeting. 0.85s. Instead of resolving the ownership issue, she sent the job to another contractor whose work order described the reserve as association common area. That sequence answered more than the gate question. 0.53s. It showed that the Board S later claim of unquestioned control had been formed after a contractor warned it about owner approval. Ben finally agreed to speak with Miriam. He brought the original email containing the first draft minutes. 0.85s. The attachment recorded 4 votes in favor and 1 abstention. Vanessa S. reply instructed the manager to revise the result to unanimous because, in her words, a divided record weakens our emergency authority. 0.85s. Miriam asked Ben the question that concerned him most. Did she tell you to falsify a vote? She said. An abstention was not opposition. Did the final minutes accurately state how you voted? 0.85s. No. We did not need him to describe a crime. We needed him to tell the truth about a board record. At the evidentiary hearing, the association's attorney challenged each step. 0.53s. He argued that the annual dollar was nominal, that insurance language protected against claims but did not determine property rights, and that a contractor West caution did not bind the association. Those were legitimate arguments to make. Aaron testified first. He explained the plat, the monuments, the easement strip, and the gate location with a single enlarged exhibit. 0.85s. He did not say who should win. He said where the recorded descriptions fell on the ground. The association attorney pointed to the resurfacing records. Your survey does not show who maintained the pavement. Does it? 0.85s. No. It does not show who paid for landscaping? No. It does not prevent an easement holder from protecting access? That is a legal interpretation. I located the physical features. His answer was careful and credible. The bank and insurer records came in through certifications and testimony about their ordinary record systems. Below me. 0.85s. Miriam laid the cleared checks beside the association ledgers. One showed payment, the other showed purpose. The association attorney returned to the size of the payment. $1 per year is not fair rent for a neighborhood road, is it? 0.53s. Miriam did not argue that it was. She asked Ben why the board paid it, to renew permission and preserve the written arrangement. He said, "How do you know?" That is what the management company told us every year. It is also how the expense was labeled. 0.53s. Did the board believe it owned Hale Reserve? Not while I served as treasurer. Vanessa looked down at her folio. Her attorney objected that Ben could not speak for every director across 15 years. 0.53s. The judge sustained the objection. Miriam narrowed the question. During Vanessa Kline's presidency, did the board continue paying the road license item? Yes. Did Ms. Kline approve any of those payments? 0.53s. 2. The payment alone did not decide the case. The insurance certificates alone did not decide it. The recorded approval clause alone did not decide it. Together, they described the same relationship from 3 directions. The title remained with the Hale family. Resident use continued by recorded easement and annual permission, and structural changes required owner approval. 0.85s. Then Miriam turned to the final minutes. Vanessa S. attorney argued that the first draft was incomplete. Ben agreed it was a draft. He also testified that his abstention never changed. 0.85s. The email chain showed the wording changed. not the vote. Vanessa took the stand after lunch. She remained composed. She said she believed the gate fell with an ordinary maintenance, and that the pavilion concept was preliminary. It was 5-3s. She said the association acted to protect residents after an unfamiliar successor appeared and questioned community access. That explanation was understandable. It was also incomplete. Miriam showed her the email I sent before construction. 0.85s. You had the deed and approval clause before the emergency meeting? I had Mr. Hale's interpretation. Did you ask him for approval? I did not believe it was required. Miriam showed her Gature hold notice. You knew the first contractor believed record owner approval was unresolved? Contractors are not lawyers, yet you changed contractors instead of obtaining approval? We changed because residents needed security. Miriam placed the pavilion term sheet beside the second contractor's work order. 0.85s. The term sheet required site control. The work order called the Reserve Common Area. Vanessa had signed both. When you authorized that description, had Hale Reserve ever been annexed into the declaration? 5-3s. The association had managed it for years. That was not my question. Vanessa's attorney objected to the tone. The judge directed Miriam to restate. Can you identify a recorded instrument annexing Hale Reserve? While 0.85s, Vanessa could not. The judge issued a written ruling rather than announcing a dramatic result from the bench. It arrived 9 days later. The court confirmed my record title and the homeowner's non-exclusive access easement. 1.5s. It found that long maintenance did not establish exclusive association control because the use had been recognized as permissive through recurring license payments, insurance records, and the written easement. It also found that the gate and card system exceeded routine surface maintenance and required owner approval. 8.85s. The ruling did not cancel resident access. It protected it. The court prohibited the association from excluding me, lowering a gate that could impede reasonable passage, constructing outside the easement, or recording an assessment under covenants that did not govern the reserve. 4.85s. It ordered the litigation notice released when the judgment became final. The judge did not award the meadow to the residents, the association, or the town. It had never left my family's title. 8.5s. He did not order arrests. He did not decide that every inaccurate minute was criminal. He resolved the property rights placed before him. After the ruling, the association's insurer encouraged settlement on restoration, legal fees, and future maintenance. 0.85s. The negotiated amount was $41,800. It covered removal of the card reader and unauthorized footings, repair to the oak post, replacement of the cut chain, a portion of my fees, and damage to the marked apple tree's root zone. 0.53s. The red gate came down under a contractor's crane 3 weeks later. I stood beside Aaron while the crew lifted the arm clear of the stone columns. The association replaced it with 2 simple breakaway bollards placed outside the travel lane. 0.53s. Emergency vehicles could pass. Residents kept their access. No one needed a card. The $9,600 assessment was withdrawn in writing. A release of the litigation notice was recorded. The pavilion plan moved to a smaller parcel the association actually owned beside its management office. 0.53s. Ben requested a member meeting under the bylaws. Residents received the original and revised minutes, the contractor timeline, and the court's findings before they voted. Vanessa defended her decisions and said she had acted for security and property values. 5.3s. Some residents agreed with her motive. Fewer accepted her methods. She resigned before the final removal vote. The remaining directors corrected the minutes and hired an independent manager to review future land projects. 0.85s. I did not attend the meeting to watch her leave. I was at the reserve with Miriam, reviewing a new road maintenance agreement. The agreement was plain. The 47 homes retained passage. The association would maintain the pavement and carry insurance. Structural changes required written approval from the landowner. Emergency access could never depend on a private card system. The reserve remained outside the declaration unless a future owner knowingly signed and recorded an annexation. 0.85s. I read every line before signing. On a cool morning in December, I rehung Raymond's weathered chain at the Orchard Lane. It no longer stretched across the neighborhood road. It marked only the narrow farm track it had always marked. 0.53s. The apple tree survived. The white paint faded after the first hard rain. Daffodil shoots from LNS Old Row had already pushed through the leaves near the pump house. Officer Ruse's sentence became the part residents repeated. He owns the neighborhood. 1.5s. The truth was less theatrical and more important. I did not own their homes, their choices, or their community. I owned the ground that my family had retained, and their access across it remained protected. 0.53s. Those two rights did not have to destroy each other. 0.85's Vanessa tried to make the dispute about loyalty to 47 families. I treated it as a question of scope, sequence, and proof. I did not cut the gate. 0.53's. I did not block the road. I noted the time, preserved the documents, hired the right professionals, and let each authority do only the job it was allowed to do. 0.85's land records matter, but patience gives them force. 1.2's. A deed in a drawer is only paper until someone is disciplined enough to connect it to the survey, the invoice, the vote, the check, and the action on the ground. Raymond was right. 1.5's land remembers what people forget. If someone installed a gate on land you owned, would you have documented it first or demanded its removal that same morning? 0.85's.